SwayamPrabha. Digital India. Educated India.
I am Devojit Kumar Sharma. I will be discussing with you on the topic of criminal justice in India as part of the course on Criminology, Penology and Victimology. When we talk about criminal justice system, the obvious thing that comes to our mind is the criminal law. For that purpose, India has 3 statutes importantly in existence: Indian Penal Code, then the Code of Criminal Procedure and the Indian Evidence Act. These 3 sets of laws govern the entire process of criminal justice administration. What we shall endeavor to do during this discussion is to delve into those aspects of these 3 laws which are directly or indirectly concerned with the administration part of it. Meaning thereby, when we talk about the criminal justice system, the authority of law which is embedded in it so far as administering justice is concerned is going to be the focus of discussion in this particular lecture. All of you must be aware about the various problems that the system is facing today. Maybe the problem of under-trial prisoners, maybe the problem of low conviction rate, maybe the problem related to hostile witnesses, maybe the problem related to victims' rights, and so on and so forth. We are nevertheless going to look at those issues also. But before delving into the problems that the system is facing, it is important for us to look at the manner in which the system is structured. But even before that, what we need to understand and appreciate is what is the premise of the criminal justice system. That means where from it draws its legitimacy. If we say a policeman coming and arresting someone, where from that policeman is drawing the legitimacy in legal sense of the term? What are the components of the criminal justice system? What are the cardinal features? What is the basis of the criminal justice system? All these things are very important for us to look into before going into or delving into the various problems and issues of the criminal justice system. But unfortunately, what happens is that whenever we talk or discuss about criminal justice systems, we directly get into the problems part of it. But then we also need to look at where from these problems are coming in, or what are the underlying reasons for the problems to happen so far as the criminal justice system in India is concerned. Now, as I have told you, what is the premise of the criminal justice system, not only in Indian context, maybe in any other country for that purpose. The very premise so far as India is concerned is the Constitution of India. As you are aware about the fact, Article 21 of the Constitution gives us right to life and liberty. And this is the system called as criminal justice system which protects our right to life, our liberty. Now, this system therefore cannot be seen in isolation from the broader social justice system. What I mean to inform you here is that criminal justice system cannot be seen in isolation from the social justice system which prevails at any particular point of time. Because the criminal law, if we have to define it, is nothing but it reflects the socio-ethical and moral values of a society at a given point of time. And if that is the definition of criminal law, be it our substantive law like the Indian Penal Code, or be it the procedural law like the Code of Criminal Procedure or the Indian Evidence Act, all these laws are more or less embedded or they are grounded on that basic principle only. Now, and these laws, be it IPC, CRPC or the evidence law, draws its ultimate legitimacy from that very constitutional article or the provision in the Constitution, that is Article 21, that the state has to ensure right to life with liberty and with dignity to every person. And that very kind of obligation on the part of the state is being ensured through, or it is being guaranteed by one system, that is the criminal justice system. Now, when I told you about the fact that the society or the social justice system in a way impacts upon the criminal justice system, what I wanted to convey to you here is that the various factors, various aspects, various contextual, cultural, economic and political factors are definitely in a way influencing over the criminal justice system or the criminal justice administration. The kind of society that we have or the kind of society that we live in, it determines the kind of criminal justice system that operates in a particular place or particular context for that purpose. That means society in innumerable way, more than the other branches of law, it influences upon and impacts on the criminal law, and so is the impact very imminent, or so is the impact very deep so far as criminal justice system or administration is concerned. As I have told you, the upholding the rule of law, that is the basic purpose or the fundamental principle of criminal justice system. And that is why we have the police, we have the courts, we have the prosecution, we have the jails. Now, all these components are primarily meant to uphold the law of the land, which is of paramount importance, because you cannot think of any civilized society or nation without the rule of law. I think that is the greatest gift of any human civilization, that we have the rule of law. Otherwise, it would have been the rule of man or the rule of tyranny. Now, how do you uphold the rule of law? It is through the very system that we have, as called as criminal justice system or the criminal justice administration. As I have just told you, that for the purpose of upholding the rule of law, we have four important components of the criminal justice system or the administration. These are: one is the police, second is the court, third is the prosecution, and fourth is the prisons. These four components together make that particular system that we are discussing today is called as criminal justice system. Now, it so happens that when a person happens to commit crime, or a person happens to commit any legal wrong in the criminal sense of the term, the first component the person encounters or comes into contact with the police. And the fact that police can arrest or apprehend any person, that is something laid down in the statutes. That is something laid down in the Code of Criminal Procedure. That is from where, that is the statute book from where the police draws its legitimacy to arrest or apprehend anyone if the person is being found guilty of having committed an offense, or not only that, if there is an apprehension in the mind of the police also, or it is reasonably suspected to have committed an offense, police can arrest a man, arrest a person. Now, the police draws its legitimacy from the very procedural law, that is the Code of Criminal Procedure. Similarly, after the police arrest the person, what happens? The process which is involved during investigation, that is what we are going to look at today. The process which is involved, or process which is adopted by the courts for the purpose of trial, is also something that we are going to look at today. What is the process? How court process a so-called criminal? That person may not be criminal in true sense of the term. Why I am saying so? Because of the reason that the person may be finally acquitted by the court. That means the person, it's every possibility is that person may be found to be not guilty, or he may be so happen that he will be proved not guilty beyond reasonable doubt. That is the standard that we have laid down so far as our criminal justice process is concerned. Now, the fact remains that what happens during the process of investigation or interrogation or apprehension by the police, and what happens when the court takes up a case based on the charge sheet being filed by the police, what are the procedure to be adopted? Let me inform you at the very outset that the process that we have adopted So far as criminal justice system is concerned, this process is called due process. It's a due process. We have to follow the process. But remarkably and interestingly, let us not forget that in our system that we have, what is important is the means, not the end at all times. That means it is the means which justifies the ends rather than the end justifying the means. That means the kind of process which is adopted by different components, different entity, different organs of the criminal justice system would determine whether the person is right and wrong at the final conclusion by the court. That means even if there is a lapse of one particular step, or if there is a at fault at any stage of the entire process of criminal justice, the person may have to be given the benefit of doubt. And there are many cases even when the person is guilty in the true sense of the term, because of certain procedural lapses, either on the part of police or on the part of prosecution, the person has to be given the benefit of doubt and the person is finally acquitted. So it is very important, and indeed it is of paramount importance, I would say, that in the system that we follow, so far as criminal justice is concerned, it is not only the substantive part of the law. It is not sufficient that we determine or identify the kind of crime that person has committed, but the procedure that we adopt to establish that this person has committed this particular wrong, that is equally important. Now, therefore, after the person is being charge sheeted by the police and other procedure being followed by the police in an entire process of investigation, interrogation or whatever, now that also has to be seen in the light of our parameters being set by the code or the statutes or from the landmark judgment of the court from time to time. Then comes the whole work of the prosecution. What does prosecution do? Is again, prosecution is nothing but an entity of the state. It represents the state on behalf of the particular, the victim of the crime, maybe. It represents the state. That is why you notice that in case of criminal cases, the cognizance is always taken by the court, by the state. The cases are named as state versus so and so. That means the burden of proof is on the state to prove a particular case beyond all reasonable doubt. The burden rests with the state, and that is the state is represented by prosecution, and they have a very huge responsibility on their shoulders. And that too, they cannot prove a case like that. That has to be based on evidences, admissible evidences in the court of law, without which the person may again be acquitted for the sufficiency of evidences. And there are innumerable cases like that. Now, what kind of evidences are to be admitted in the court or admissible in the court? What kind of process to be adopted by the court? These are again very much intrinsically linked with the administration or the process of criminal justice. Now then comes the role of court. Very interestingly, the system that we have adopted, we call it adversarial system. The judge plays the role of a neutral umpire. It is like a football match where you have two parties who are playing the football match, and you have an umpire who is neutral. Similarly, in the system that we follow, in the courts, the judge plays a very neutral role. Based on the arguments from both the sides, judge has to come to a logical conclusion. With reasons, the judge is also supposed to be giving reasons for every case being decided by him or her. Now, then comes, if the person is being acquitted, the person can go home, he can go back to the society where from he has come. But if the person is being convicted, the person is sent to jail or the prison for that matter. We have already discussed about prison administration during our previous classes. Now, when the person is being sent to the jail, on the order of the court, the person has to spend that duration of sentence that being ordered by the court for him. That means if it is for 10 years of imprisonment, that cannot be reduced to less than 10 years by the court, by the prison or by the jail authorities. At the most, what can happen is the person can appeal to a higher court to reduce his sentence. Now, after the person spends considerable or whatever, not considerable, rather it would be the kind of mandated duration of sentence or the quantum of sentence being ordered by the court, what happens? The person has to go out of the jail. Person has to go out of the prison. I give you an example. A person has stayed in the jail for 10 years. There was no mercy, no remission. He stayed for 10 years as per order of the court. Now, the day has come that he has to move out of the jail. Now, where would he go? He has to go back to the same society, same family from he actually came originally. But what has happened to him? The kind of experience he carries during the entire process of criminal justice, that is something that he carries with him. Now, it also depends whether society would accept the same person as a part of the, as part of their own family or as part of their own community. That's a different thing altogether. But it is from the society that the person commits a crime, and if found guilty, the person has to spend time in the jail. Then after that, the person has to come back or to go back to the same society. Now, here stands a little man, I would call it, and he is completely, kind of helpless in a manner that the entire state machinery is before him. You call police, again, police is the state representative. You name it as court, again, court comes within the definition of state. It's given in the Constitution, again a machinery of the state, or of course, judiciary is independent of the executive. But what I am trying to bring to your kind notice here is that essentially the court is also an entity of the state. You call prosecution, obviously prosecution represents the state in all criminal cases on behalf of the victim. Then the jail or the prison, as I have told you in our previous lectures, that the prison is a state subject. There is every authority of the state to have control over the prison or the prison system in a state. So, this little man is standing before the system, and the system is processing his case or her case. So, what is important to look into that? His or her rights may be violated by the different functionaries or different players in the criminal justice system. That is where the very aspect of human rights comes in. That is where the discourse on criminal justice and human rights comes in here. That means, to what extent the rights of that person who is being processed by the criminal justice system, are being protected by the system in itself. Because there are cases where state is reported to have violated the rights of the people. We often talk about the violation of rights in the prisons, but it's not only prisons, or it's not only at the level of police, but there can be violation of rights of a person processed by the entire criminal justice system at any point of time. That is very much possible. Now, what are the guarantees that his rights will not be violated? That is something we need to take up, we need to look at. Now, these are some of the very important concerns that we have when we discuss criminal justice system, because this is not a system like other systems which may be prevailing. We have these institutions such as prison, which is completely a closed setup. No external interference is allowed inside the jail. The society outside the jail may not really know what happens inside a jail. Under such circumstances, how would you ensure that rights of the people processed by the criminal justice systems are being protected? Where from we get that kind of guarantee? Who guarantees that? The state has to do it, because state has got also an obligation to protect the right to life and liberty of the people. So when you say the right to life and liberty of the people, it's not only that the rights of those people who have not committed crime. It also extends to the level of people who have been processed by the criminal justice system, because it may so happen in maximum cases the people are found not to have committed a crime, maybe because of whatever reasons it may be. Now what happens to these people? If after spending considerable years in the jail, when the trial goes on as an under trial, we have the famous case of Rudal Shah versus State of Bihar, we have the case of Hussain Khatun. I think these are landmark judgments of the Supreme Court you must be aware about. What happens to these people? How the society is going to look at that someone has been arrested by the police for no reason or for different political consideration, maybe at times. Now it's not only that the person has been arrested, person has been sent to the judicial custody. After that, the person was produced before the court of law, and it so happened that the pendency of cases, therefore there is a delayed justice, and during the pendency of the case, the person has to spend his days and nights altogether. It may even go up to years, nowhere but only at a place what is called as jail. That is the custody. The person cannot be kept in the police custody because that is not allowed by the Code of Criminal Procedure. The only place the person can stay during the pendency of the trial is the jail. And they are given all minimum basic facilities in the jail, but then staying in the jail becomes very important because the person is not allowed to live with his or her family unless of course there are some provisions. Again, that has to do with something to do with right to life and liberty. That is called if someone is released on bail. We have the provision, and nowadays of course things are much improving, that people are being released on bail, because in CRPC we have two categories of offenses. One is the bailable and second is the non-bailable. But remarkably nowadays what happens is that on a practical side of the law, in cases like POCSO, child sexual abuse cases, the person, the accused has to spend at least some time in the jail unless he is being released on bail. So that is also there. Now in non-bailable offenses again, it's not that bail cannot be given at all. It can be given based on the discretion of the court. But in bailable offense, yes, that becomes a kind of right on the part of an accused. If one is released on bail, no problem. Again, if the person is found guilty, the person may be released otherwise than to be kept in the jail, like the probation. That is also a possibility. But when it comes to the effective implementation of such laws, we find that there is much to do in the country like India today. Now coming back to the very components of the criminal justice system that I was talking about, these four components together make our system. At least so far as India is concerned, these four components are doing a remarkably good job, I would say, depending on or considering the fact that we have a huge population. There are criticism against the system, there are criticism against the police, courts, that they delayed justice. Justice is kind of not being done in an expeditious manner. But one also has to remember that the kind of population we have and the ratio between the judges and the population and the number of police personnel that are being in the payroll of the state. Now considering all these factors, I would really say that at least the sincere endeavors have been going on the part of the criminal justice system to address the issues of crime in the society. Because crime is such a thing that is very difficult to predict. Today it may so happen that everything is fine, but tomorrow morning when you wake up in the morning, you find that everything is not fine. Things might go wrong. Now in such a situation, the criminal justice functionaries are also human. How do they address? How do they tackle the situation? We have the problems like terrorism, insurgency. where are these laws that we have in the country are sufficient for that purpose, or we need something else. Now, if we say that these laws are not sufficient to address or curtail problems like the terrorism, insurgency, and the separatist movements, what kind of changes are required? That is also one of the concerns of the criminal justice system. Now, going back to my initial point of reference, I told you about the adversarial system. Now, as the very word goes, adversarial system. Now, why is it called adversarial? When we say adversarial, immediately the thing that needs to be remembered here is that these two parties are adversaries to each other. That means they are enemies to each other. Now, what do you mean by enemies? That means in the court of law, what happens is there are two parties, two sides. One is the prosecution, which represents the state or the victim. On the other side, you have the defense or the defense counsel on behalf of the accused, and both the parties or the advocates, they argue a particular case. When they argue based on their own sides of submission, or they're based on their own evidences, and finally the court has to take the final call, or the court has to determine whether the person is guilty or not. Since the two parties or the two sides of the court system, they argue, or they are like the enemies to each other, that is why we call it adversarial. And the other system which is prevalent in many other countries in the country is called, many other parts of the world is called inquisitorial, where the things are quite different. They are not adversary parties, but the things are based on different parameters altogether, about which I am not going to discuss because our lecture today is confining to the criminal justice system in India. Now, the system that we have, the adversarial system, is governed by, or it's ruled by three important, I would call it again, three important laws. One is the Indian Penal Code, one is the Code of Criminal Procedure, and third is the Indian Evidence Act. Of course, from 1st July 2024, we are going to have new set of laws, new sets of criminal laws in the countries which are going to come into effect. The Ministry of Home Affairs has already notified regarding that, replacing the earlier IPC, CRPC, and the Evidence Act. But then if you see the changes which are being brought in are very important considering the contemporary challenges in the country. IPC, there are some drastic changes. CRPC, there are some remarkable changes. But yes, Indian Evidence Act, there are not much changes, but then there are some additions into it. So it is hoped that the new criminal laws are going to revamp the entire system. It has got different positive features to it. Maybe for that, again, a different kind of discussion is required. But then since our discussion pertains to criminal justice system, we may have to, that's why the reason I'm referring to even the new criminal laws which are going to be rolled out from the 1st July. And it is, the time will tell to what extent these new laws are going to address the problems that we are facing in the system today. Now, when I said the adversarial system, please understand that is not the only thing that is important for us to understand so far as criminal justice process is concerned. One of the most fundamental premises is called right of silence that our criminal justice is based on. It's a constitutional guarantee. Then we have the presumption of innocence. Every person has to be presumed to be innocent until proven guilty. That is again one of the very important features or the parameters of the criminal justice system. Now, to what extent police presume a person to be innocent? That is for us to see at the practical level. To what extent the prison staff or the officials presume someone to be innocent? That is again for us to see. Now, we have to ensure that during the entire process of criminal justice, this presumption is not lost. This presumption is not diluted until the person is convicted. And that is the reason precisely why, when in the jail you find three categories of prisoners. One is the under trial, whose trial is going on in the court, maybe for years altogether. Again, that cannot be blamed, the courts cannot be blamed, because justice hurried is justice buried. At the same time, justice delayed is justice denied. It's very interesting, when you say that justice delayed is justice denied, at the same time one may also argue that justice hurried is justice buried. Justice cannot be done like that, because we have the set of procedures to be followed. Now, if the police or the court or the prosecution does not follow those procedures, what will happen? Nothing will come out of the thing. Reason lies, that's why I told you at the beginning that the system that we have adopted, it is not only that India has adopted this system, it is the most of the Commonwealth countries have adopted adversarial system. It is not that the inquisitorial system has got no advantages. Without getting into the debate of which is better, adversarial or inquisitorial, let me inform you that in the circumstances or in the situation or context that India is situated, or India was situated at that point of time when this system was adopted, I think that was the best suitable system for us. Now, when you say that adversarial, again we don't have to be ignorant of the fact that we still have certain features of the inquisitorial system embedded in the criminal justice processes, embedded in the criminal laws in the country. Now, another important feature is proof beyond reasonable doubt. Very important and interesting. A particular guilt of the person has to be proof beyond reasonable doubt. So, there is a debate and discourse which always exists between truth and proof. Truth may be something else, but decisions in the criminal court will depend not on the truth but on the proof. So, the quest for truth and quest for proof is something that needs to be understood very clearly and carefully. We can also say that it's a quest for justice rather than quest for proof. That should be the ultimate purpose of criminal justice administration, but nevertheless, for all practical purposes, we have to remember the fact it is the quest for proof rather than quest for truth in the system that we have in the country today. Now, since I told you about the adversarial system, I also told you it's like a football match where you have a neutral umpire who decides or neutrally, take the role to decide which side, the arguments of which side is more powerful. Now, what happens is that the winnability, or in the football match, the side which wins, or the party which wins, depends on the number of goals that the side secures. Similarly, in the system that we have, either the prosecution or defense side, who wins depends on the kind of evidences being adduced in the court of law. And there are strict evidentiary rules also. When I say strict evidentiary rules, that means not that any or every evidence can be produced in the court of law. There are certain standards being laid down. Say for instance, the Indian Evidence Act says the confession made before a police officer is not admissible. Anything under trade inducement is not admissible. Now, that is why there is a controversy regarding section 161 CRPC. Any statement being recorded by the police has got no evidentiary value at all, unlike section 164 of the CRPC, where statements are recorded by the magistrate. Now, if that is so, the controversy surrounding low conviction rate is central to the debate pertaining to sections 161 and 164. Now, if the statements being recorded by the police have got no evidentiary value, what is the reason that police has to record the statement? Why not 161 can be clubbed together with 164, so that anything being done by the police has got some value in the court of law? That means, if this has got no evidentiary value, now what is the purpose of police recording statements? Now, if police does not record statement, that again becomes a procedural lapse. And when police goes to investigate a case or arrest someone, police at times doesn't have the time to look at what is written in the CRPC. They go by the practical consideration rather than the statutory consideration. The case diary. At times police fail to even fill that case diary. For that they have miscellaneous diary they carry at times. And the court wants that the case diary should be produced because that is something laid down in 161 of the CRPC. Now, these are the practical problems that one has to see when we talk about the problems of the criminal justice system, because it's very easy to criticize the system. But then to understand how the system operates and where does the actual problem lies is something, is a matter of very introspection by every concerned person. Now, as I have told you, this adversarial system is not only that India follows, every Commonwealth countries have been following that. Now, in ancient times, what used to happen? The physical battles were there. Now, physical battles were won by the might of sword. But nowadays, what happens? Any person committing crime, whether the person is guilty or not guilty will depend on what kind of arguments can be given in the court of law. Police job ends at the level of filing the charge sheet. After that, police has got no role. Of course, the prosecution represents the police and whatever the work the police does. But when it comes to the finding of the guilt of the person or innocence, the proving the innocence, establishing the innocence of the person, it all depends on the arguments. That means in modern sense of the term, the battles are won by the advocates in the court of law, by the arguments, by the words, on the basis of evidences. You do not need the power of the sword. You do not have to fight battles in the battlefield. What you need to do, the battlefield is, the real battlefield is the court, the courtroom where battles can be fought to establish the guilt or the innocence of a particular person. Now, truth is arrived. When I say the mission is not to look at the truth, the mission is look at the proof, but the truth is arrived. So, in the proof itself, we are trying to see the truth into it. Now, truth is arrived as per process laid down in law, in which every fact in issue or the relevant fact is examined with the aid of evidences. You have different categories of facts, different categories of fact in issue and relevant fact. Now, these things are examined. Whether the person has actually done this or not done this, or whether somebody else did that, whether at the time of commission of the offense, or if I commit or someone commits suicide today, whether the person leaves behind a note, suicide note as we call it, but one also has to examine the fact whether the suicide note is actually written by the person who has committed suicide. Now, again, that is where the role and relevance of expert evidence or the experts come in, handwriting experts. The handwriting expert will examine whether the suicide note was written by the person concerned. Otherwise, it may be written by someone else after killing that particular person to give an impression that person has committed suicide. So, these all things have to be examined very meticulously, and this is the process laid down. That's why I call it criminal justice process or the system. Even at one stage, even at one point of time, if anything is being ignored either by the police or the court, the prosecution, any entity for that matter, the entire case becomes null and void. Of course, there could be certain procedural, I think I would call it not lapse, but then inadequacies, inappropriate ways of adhering to a procedure. Those things can be excused, may be excused by the court, but if they are deliberate procedural lapses, there is no mercy. Because of procedural lapse, the case may be null and void, and the court may say that the guilt of the person cannot be established. It's not that person has not committed the wrong. Either the person has committed, there are only three possibilities. Either the person has committed the offense, the person is convicted, or the person has not committed the offense, the person is acquitted, and the third category, that I am trying to know it is written, but I am trying to help you understand this whole dynamics of criminal process. The third category can be the case cannot be proved beyond reasonable doubt. But let me tell you, this proof beyond reasonable doubt only happens in case of criminal justice. It happens only in case of criminal law, whereas in civil cases, that is not required. In this particular, though it is not related to criminal justice, but then let me inform you that in many departmental proceedings that we have, when I say departmental proceedings, that means we have something called CCS rules, Central Civil Services rules, which are applicable to different institutions and universities pertaining to employees. Now, in those disciplinary proceedings as per the CCS rules and other things, what is required is not proving beyond reasonable doubt, but the standard of proof is preponderance of probability. I repeat, it is not beyond reasonable doubt in civil cases like the departmental proceeding, but the standard of proof is preponderance of probability. So, in criminal cases what happens is that there should not be even an iota of doubt left regarding the guilt of the person. Even if there is an iota of doubt, the person has to be given the benefit of doubt, because every person is presumed to be innocent until proven guilty. That is the cardinal feature. That is why number of cases are lost in the courts, but this is the system that we have, and this is the important feature of the system. Now, complex evidentiary rules that I have told you determine the kinds of material admissible in the trial, and the burden of proof is always higher on the prosecution. Now, it is not that the burden of proof is not on the defense side. There are cases, especially in the offenses against women, the sexual offenses, there are some exceptions where it is for the defense to establish that the person has not committed the wrong. We have section 100, section 101, 102 and the subsequent section in the Indian Evidence Act, where you will find the difference that it is not always the prosecution that has established the that is the beyond reasonable doubt, but in some cases, that's why I told you that we do have the features of inquisitorial system also embedded in the criminal trial or the criminal process, but that is again exceptional cases. But in normal circumstances, beyond reasonable doubt becomes a very important thing. That is why it's not very easy. There can always be a doubt regarding whether the person has committed the wrong or not, because what happens is that in most of the cases, in most of the varieties of crimes, there cannot be any direct evidence. Now, if I stand before you, it's not that you are going to commit a crime. Anybody who commits crime, of course, he or she would take all care and precaution to ensure that there is no evidence around, there is no person around. Now, because of such eventualities, because of such circumstances, direct witnesses are very difficult to find. Now, even if direct witnesses are found, another problem which is associated is that the witnesses turning hostile. Now, witnesses which may be forthcoming to the police, they will give all their statements. Now, when they go to the court in the actual process of trial, what happens is that they turn hostile. Now, why do they turn hostile? There is again a matter of debate. But the fact remains that the hostile witness is one of the important challenges the system is facing today. Now, I have also referred to regarding 161 and 164 of the CRPC. Now, whatever statements the police has recorded, it has got no evidentiary value, and that is also one of the reasons why many of the witnesses turn hostile at the stage of trial in the court of law, and there are different factors for it. Coming to the basis of this adversarial system, because as I have told you, our system is embedded in the adversarial notions of justice, but what is the theoretical premise of the adversarial system? The premise is that the person who is being processed by the system has to be given a fair treatment. His or her rights have to be protected. At no point of time his or her rights can be violated by the criminal justice system or the process. That is why it is said that this system gives an equal opportunity to both the parties and ensures that there is no arbitrary exercise of power by the criminal justice functionaries. There are reported cases where criminal justice functionaries at times abuse their powers. When I say abuse, it means that they exercise more powers than what is being mandated in the statutes. And the moment there is abuse of power, there is a violation of human rights. Why I say violation of human rights? Because the National Human Rights Commission, which is established under the Human Rights Act of 1993, says that human rights violations can only happen, any application of human rights violation can be filed only against public officials. That means if a particular person violates the rights of another person, the forum is the court, forum is the police. But if the person who is violating the right of the another person happens to be a public official, or it may not be that the person has to be an employee, but even if there is the persons working in the banks and persons working in the autonomous institution, they may not be directly the employees of the government, but they are the public servants. The appropriate word would be public servant. The NHRC, the Human Rights Act, says that any public servant, if he or she violates your rights, please come to us, we will take care of him or her. So the moment the police or any functionaries of the criminal justice system abuses or exercises more power than what is being laid down, that becomes a case of human rights violation. Now, what happens here is that those kind of tendencies on the part of the criminal justice functionaries or different functionaries of the criminal justice process have to be checked. There cannot be arbitrary exercise of power by any authority for that purpose, for which we have the system in place, for which the adversarial system ensures that, because at every point of the process, it may go up to years altogether. We have the instances where people have stayed as an under trial in the jail for 14 long years. It's the case of Rudol Shah versus State of Bihar, 14 years as an under trial, very surprisingly. Now what happens? Even during that period of time, after that he was given compensation, as he was said that he was a victim of criminal justice system. That is a different thing altogether, but the kind of abuse of power that's happening is also something that needs to be looked into. Now, as I've told you, this is again the basis or the theoretical premise is the truth finding. Now, how do you find the truth? As I told you, that crime is not going to happen just in front of you. If people are around, no one is going to commit a crime. Crime is something that is, always that happens in isolation. That happens when no one is around. Now, if that is so, the crime becomes a historical fact. Why do I say historical fact? Because if a crime is being committed, that becomes a part of history. Maybe yesterday, maybe day before yesterday, maybe 1 month before, maybe 1 year before. Now, by the time the case comes up in the court of law, it may be 3 years, 5 years, 10 years. The witnesses do not remember what has happened. Now, the moment the police call the witnesses or evidences, at that point of time, the witnesses may remember what actually has happened. But after 5 years, after 10 years, after 3 years, when the trial happens, it may so happen that they forget. The human memory may fail. Now, therefore, the best way to ascertain what has really happened is through arguments. That is why it is called as truth-finding theory. Let's argue, and the argument happens between two sides. One is the prosecution, one is the defense. Now, there is also the aspect of cross-examination of witnesses. That's very interesting and one of the important and powerful features of the system that we have. You cross-examine of the witness so that the truth comes out. Truth is kind of derived from their mouth. Now, we also have the fact of dying declaration. When if somebody dies, it's said that a person who is to die, he would always speak the truth, nothing but the truth. Now, this is the reason why we have this particular theoretical premise, the truth finding. Second is the fair decision. That means if the fairness has to be ensured, both to the state and individual, there has to be adequate safeguards for the accused also. Maybe the defense against self-incrimination, independent judges, standard operating procedures, and so on and so forth. Now, beyond the scope of adversarial system, it's also important for us to look at the model that we have adopted. So far as India is concerned, we have adopted the model called due process. The statement that I made before some time, that it is the means which justifies the end rather than end justifying the means, so far as criminal process in India is concerned. That means the whole emphasis is on the rights. It's a rights-based approach that we take, and rights of whom? Rights of the accused. But it's not that victims' rights are not taken care of. Of course, there are sufficient safeguards, and in the new criminal laws, there are certain important and profound amendments which ensures the rights to the victims also. That has been one of the debatable concerns, that in the system that we have, it is more lenient towards the accused, but least lenient towards the victim. What happens to the victim? But the new set of criminal laws is trying to strike a balance. And importantly, what happens also is that on the question of sentence, at times in serious offenses or at the time of giving bail in case of offenses like rape, the prosecution has to be also heard. That is something a part of the criminal procedure code. The prosecution is to be heard means prosecution represents the victim. So indirectly, victim has also got a role to play, but not unlike the inquisitorial system. And in many countries, victim plays a very, very active role in the criminal justice system, unlike the existing system in the country like India. So, in the due process model, the process is given more importance rather than the output, whereas rather than the outcome of the process. Whereas in the crime control model, what happens is that the control of the crime at whatever cost, what is of more significance is the crime control, or indirectly the social control. Now, in our case, we are more concerned about the parameters of human rights, which extends to not only the common citizens, but also the citizens or the persons who happens to commit crime or who are being arrested or negotiated by the criminal justice system for being their reasonable suspicion that someone has committed a crime. Now, on such grounds, if people are processed by the system, then we go by the due process model. I already mentioned to you regarding the very fundamental article in the Constitution, that is right to silence. Now, Article 23 talks about the fact that no person accused of any offence shall be compelled to be a witness against himself. So, it is from that very constitutional article that this right to silence, we derive that right to silence, which is applicable in all cases of criminal justice process. Then the presumption of innocence, again Article 20 and 21. It is the presumption of innocence, this principle is based on these two articles of the Constitution. Now, the reason that we have the presumption of innocence, that is why it is said that the moment the normative standard of proof are substituted by preponderance or probabilities, there will be violation of the basic human rights, which the Constitution has embraced. So, it cannot be taken lightly. Everyone has to be given the same right. Everyone has to be presumed to be innocent until proven guilty, so far as Article 20 and 21 is concerned. Now, proof beyond reasonable doubt, I have already discussed. I am just trying to conclude the important points here. Now, someone said that if we try to doubt everything, we shall find that there is nothing of which we can be certain except our ability to doubt. But then, this is again very important and one of the cardinal features of the system that we have adopted. And lastly, if I have to take you to the important and the most emerging problems in the criminal justice system, as I have told you, the low conviction rate. That is one of the reasons that we have very, the statistics that the Ministry of Home Affairs comes up with, we find that the convictions are very less. Not only one state, but then in India as a whole, the conviction is very less. Now, what are the reasons? The one reason is, as I have told you, that is being cited by many the advocates of the criminal justice system or the many concerned person of the criminal system, is that the 161 and 164, something that needs to be done regarding that. Now, second thing that I have told you was the hostile witnesses. Increasing number of hostile witnesses or increasing number of witnesses turning hostile is an area which really needs to be looked into. And fortunately, in the new set of criminal laws, we have something called a witness protection scheme, which is, I presume that that's going to really serve a purpose, which is actually very important for a country like India. Now, delayed justice. Why delayed justice? I think the reasons may be known to all of us. Search sheets are not at times filed on time. Now, under the new set of criminal laws, it is being laid down that charge sheets are going to be filed within time, charges have to be framed within 7 days, and judgments have to be delivered within 45 days. That is one of the things that the new criminal laws are going to do. And again, the prosecution is another challenge, that the quality of prosecution is not uniformly good in the country as a whole, but in the new criminal law, it is being laid down that there would be directorate of prosecution to take care of the conviction rate or to increase the conviction rate, and who would be assisted by additional and assistant prosecutors. And this is what, in brief, I wanted to inform you about the system that is prevalent in the country so far as the criminal trial or the criminal process is concerned. We have looked into the basic normative features, we have looked into the theoretical parameters, we have also looked into the challenges and the issues that the system is facing. Now, in this totality, we have to take our own stand, whether the system is functioning well, whether the system is functioning adequately or not. But fortunately, as I have already told you, the new sets of criminal laws are definitely going to revamp the system. That is the hope that we all can have. Thank you so much.